I'm joined by Harry Litman of the Talking Feds YouTube channel, Talking Feds podcast. We've got some breaking news, Harry Litman. Judge Hellerstein, federal court judge who had previously denied Donald Trump's attempt to remove the Manhattan District criminal case to federal court, years ago at this point when Trump first tried to do it, has just denied Donald Trump's attempt to remove it to federal court. Again, granted on a technicality, but let's face it, the law is about technicality. So you and I and others on the MeidasTouch network previously reported that Donald Trump tried to remove the Manhattan criminal case where he's already been convicted on 34 separate felony counts, where sentencing is set to take place on September 18th. So right around the corner, where Justice Merchan is expected to rule on absolute immunity issues by September 16th. So a lot is going on. And now Donald Trump and his lawyer said, you know what? State court, yeah, we went through the trial. We did all of that. We filed an immunity motion here. We did. Let's go to federal court now, though, and let's remove this case, which I think is all about delay, getting it in front of a federal judge and trying to stop this sentencing from happening on September 18th, which I think Donald Trump is terrified of. It's a long intro, but let me just read, Harry, if I can, the notice of deficiency in filing, which is like an extra way, I think, of federal Judge Hellerstein kind of almost trolling Trump as well, not even doing like a actual order that goes over it. Just like, this is a deficient document. Let me just show you what hit the docket moments ago. You see August 30th, 2024, notice of attorney regarding deficient pleading. Notice to attorney Emile Bove to refile the document, notice of removal. The filing is deficient for the following reasons. The PDF attached to the docket entry for the pleading is not correct. The wrong event type was used to file the pleading. Court's leave has not been granted. The order granting permission to file the pleading was not attached. Refile the pleading using the event type amended notice of removal found under the event list complaints and other initiating documents. Attach the correct signed PDF. Select the individually named filer and filers. Select the individually named parties to the pleading it's against, and file the exhibit to the pleading event found under the event list, other documents, and attach either the opposing party's written consent or the court's leave. Now, Harry, we know Judge Hellerstein has not granted leave, so he could have just said, submit it to me, but he did it this way. What do you make of the way this minute order, this paperless minute order is drafted? What does it tell us, and what do you make of this event?
This is humiliating. So Hellerstein basically took down Emile Bove's pants and spanked him in public. So first, it was already a desperate move, not simply delay, but for a specific kind of delay, Ben, is how I read it. So yes, he's already tried before to remove it. So now he's doing it again, and I think it's destined to fail in several ways because it had already been decided before, what lawyers call res judicata. Because Trump, after it was decided before, didn't take it up or abandon it to the Second Circuit above Hellerstein. So that would be waiver. And because on the merits, there's no argument, as there was before, and the same reason it was denied, that he was acting in his official capacity when he was giving hush money to a porn star. But I think what he was hoping to do, when you do removal, as you know, it automatically goes into the federal system, at least for a moment, until it's denied. And I think he was hoping to sort of work it in a way that maybe brings it up to his friends in the U.S. Supreme Court and could keep things frozen through September 18th, when, as you say, he fears and loathes the prospect of this sentence. It's even in his filing. This would be egregious and terrible, irreparable harm to me as a political candidate. So Hellerstein could have done several things with it, including just deny on the merits, and he could have tried Trump to go up. Instead, this is the absolute schoolmarm wrapping his knuckles. there's no appeal here. What are you going to say? He got he did all these things technically wrong, which Trump often will do and doesn't care about. So it's absolute back of the hand. And now, by the way, he's got to either get Mayor Chan's approval or the consent from the DA. I don't see that happening. So I think this road, which he embarked on and never made much sense, is shut down anyway. But it's in particularly humiliating fashion, given the abusive way Trump and his lawyers have treated the New York courts and Mayor Chan in particular. It's really sort of appropriate how they're slapping him around here. But I think what it really nips in the bud is an effort to just have this gum up the works and have them still be gummed up on September 18th. Now it's back in Merchan, back in the state court, ain't going anywhere. Doesn't mean, and we can have a different discussion about whether Merchan will do the sentencing on September 18th, but it does mean this really desperate maneuver not only fails, but fails in a really humiliating fashion.
So look, we have state court, we have federal court, right? We have the criminal proceedings were brought by a state prosecutor, a Manhattan district attorney, in a state court before a state judge, Justice Juan Merchan. There's also a federal system where there are federal issues are decided in federal courts, or where a statute requires it be treated in a federal court, or where there could potentially be an issue of a diversity jurisdiction. But under set circumstances, a case can involve federal laws, federal issues, and that's why it would be in federal court. One of the things that Donald Trump tried initially when the criminal charges were brought, this was 2 years ago at this point or so, you lose track of time, was to remove it from state court to federal court. Remember, there was a whole evidentiary hearing that was held before Judge Hellerstein. Donald Trump's lawyers did not fare very well there. There were witnesses who were even called to testify. The district attorney, I remember, cross-examined witnesses. And then Judge Hellerstein said, this does not belong in federal court. These are state crimes, state statutes, nothing to do with federal court. And there was also an issue of waiver, that Donald Trump had waived certain things that would otherwise make it to state court because Trump didn't want to make certain admissions of the time. So it gets sent back to state court. It goes through all of the proceedings that happen in state court criminal cases. It goes before a jury. The jury convicts, unanimous jury. We go through all these kind of lead up to the sentencing. And then Donald Trump and his lawyers then go, you know what? I just want to give people the structure in their mind. You know what? Let's go back to that federal court, because now with what the Supreme Court did, and said that there's this federal immunity, this absolute constitutional immunity. Now we want to take this because there are now these new federal issues, they argued, which wouldn't necessarily be new federal issues, but they're federal issues. Let's go to the federal judge. And to do that, when I said at the outset there are technicalities, you either have to get the consent of the district attorney because the case is already done. There's a jury verdict. So the law says you can't just willy-nilly go bring it back up, to federal court. Get the consent or get leave of the judge and go through the judicial process, follow the rules. Because Trump didn't follow the rules, the federal judge didn't even address this fairly long filing by Donald Trump on its merits. Like Judge Hellerstein, the federal judge, could have issued an order that cited case law. But what they did is, it's sometimes like where a paralegal screws up in the filing and maybe the paralegal includes the wrong lawyer's name or includes the wrong document. Maybe it's form A088, but they meant to do the A086 form or whatever. So the clerk rejects it in a minute order that looks like that. And when you get that at your law firm, you usually the law partner or the senior associate, or whoever, will go to you. What, you made me look stupid. What are you doing? And then you'll be like, well, you're the lawyer. You should be checking, your filings. We've all been there before, though. We're not impervious to that. But at such a high profile matter, to get the the treatment of you filed the wrong form thing. Is Hellerstein at another subtle level kind of digging in, huh?
And not even so subtle, and just a few points here. So again, that given that he rejects it for this reason, Trump can't appeal that. He can't go to the Second Circuit and say, oh, my PDF was really the right kind. It was the wrong kind. So he is out of luck and out of court. Now, removal is the whole idea here. Removal is kind of a kissing cousin of immunity. He wanted to say there's a reason you have a removal statute. That's because you're a federal official and state courts are going after you for something you did as part of your federal job. And there's the law that says so you can go to federal court where presumably you get a fair shake. So in that sense, it raised the same question. Were you working in your federal job? And what they had decided already, and this augurs poorly for Trump in his immunity motion, is that no, he wasn't acting in his federal job when he did this stuff. And that's a similar kind of ruling. And the final thing I want to note is, just as you said, he was trying to say, oh, we have new law here. But New York actually makes it clear. A new opinion, even from the Supreme Court, that's not good enough reason for you to revisit this. So it was going to fail 8 ways from Sunday. But the way that Hellerstein did it, first, I think is sort of personally humiliating to the lawyer. And then second, gives him no immediate appeal, no way to sort of monkey with the system on his way up to his friendly forum in the U.S. Supreme Court. So it's a pretty sharp comeuppance for some pretty sloppy lawyering, as you say.
There you have it, Harry Litman. Make sure you all subscribe to Harry Litman's YouTube channel. It's Talking Feds. Talking Feds YouTube channels where I get my legal news when I really want to geek out. You should go there. I'm not calling you a geek. I just say I like to geek out. Go search Talking Feds YouTube. Harry, have a wonderful weekend.
Same to you.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.